5 seconds to go. Start. The appellants did not specifically deny their ownership of the suit property in their written statement before the trial court. By taking the plea of adverse possession, the appellants implicitly admitted the respondent's title. Under Order 8, Rule 5 of the Code of Civil Procedure, failure to deny an allegation of fact amounts to an admission. The respondents argue that the state cannot perfect title over private property through adverse possession against its own citizens. Allowing such a claim would be contrary to the principles of a welfare state and undermine citizens' constitutional rights. The respondents contend that the appellant's possession of the suit land was permissive and not adverse. The Misal Hakiyat of 1879-80 Exhibit DW10/1 indicates that the state's possession was conditional, described as Bikhar Bahali Kaza, meaning till the existence of an orchard. Acts such as placing bitumen drums or constructing temporary structures do not amount to adverse possession. The trial court rightly held that such acts do not constitute possession sufficient to establish adverse possession. The respondents have established their ownership through continuous entries in the revenue records Jamabandis from 1904-5 to 2019-20. Plaintiff number 1 derived title through a registered sale deed dated 5th July 1960 and plaintiff number 2 through a sale deed dated 12th March 1973. Mutations were duly sanctioned based on these sale deeds. Revenue records are records of rights and are admissible evidence to prove ownership. Since the appellants did not deny the respondent's title, the burden was on the appellants to prove that they had become owners by adverse possession. The appellants failed to discharge this burden. The trial court correctly found that the appellant's possession, if any, began in 1980 and was insufficient to establish adverse possession. Having heard the arguments advanced by both parties and perused the records, the core issue before us is whether the High Court was correct in setting aside the judgment of the First Appellate Court and restoring the decree passed by the trial court in favor of the respondents' plaintiffs. The appellants challenge the High Court's decision on several grounds which we shall address in their turn. The appellant's contention that plaintiff failed to prove their title and ownership is completely misplaced for the reasons and analysis made hereunder. We find this argument unconvincing for several reasons. In their written statement before the trial court, the appellants did not specifically deny the plaintiff's ownership of the suit property. Instead, they primarily relied on the plea of adverse possession. Under Order 8, Rule 5 of the Code of Civil Procedure 1908, allegations of fact not denied specifically are deemed to be admitted. By asserting adverse possession, the appellants have impliedly admitted the plaintiff's title. The plaintiffs relied on Jamabandi entries to establish their ownership. The Jamabandi for the year 1969-70, Exhibit P1, records the name of Sri Amin Lal as owner to the extent of half share. Revenue records are public documents maintained by government officials in the regular course of duties and carry a presumption of correctness under Section 35 of the Indian Evidence Act 1872. While it is true that revenue entries do not by themselves confer title, they are admissible as evidence of possession and can support a claim of ownership when corroborated by other evidence. The respondents have produced copies of registered sale deeds and mutation records before this court, which were part of the additional documents filed with the counter affidavit. Plaintiff number 1 Shri Amin Lal derived title through a registered sale deed dated 5th July 1960 and mutation number 8329 was sanctioned on 20th April 1982. Plaintiff number 2 Shri Ashok Kumar derived his title through a registered sale deed dated 12th March 1973 and mutation number 8330 was sanctioned on 20th April 1982. These documents establish a chain of title and cannot be ignored. The appellants did not dispute the plaintiff's title in their pleadings or during the trial. The first appellate court's finding that the plaintiffs are not the true owners is based on conjecture and lacks evidentiary support. The appellants cannot now, at this appellate stage, challenge the plaintiff's ownership without having raised a specific denial earlier. The appellant's next submission that the burden of proof lay on the plaintiffs to establish their title is equally not borne out from the records. It is a well settled principle that in a suit for possession based on title, the plaintiffs must establish their ownership. In the present case, the plaintiffs have done so by producing revenue records and subsequently the registered sale deeds and mutation entries. Furthermore, as the appellants failed to deny the plaintiff's title specifically and instead relied on adverse possession, the burden has shifted to the appellants to prove their adverse possession. In the present case, the plaintiffs have sought possession based on their title, which they have established through documentary evidence. The appellants claim that due to their long and continuous possession of the suit property since 1879-80, they have perfected their title is also not sustainable in law. However, it is a fundamental principle that the state cannot claim adverse possession over the property of its own citizens. In Vidya Devi versus State of HP, this court emphatically held that the state cannot be permitted to take the plea of adverse possession. The relevant paragraphs from this judgment are reproduced hereunder. In a democratic polity governed by the rule of law, the state could not have deprived a citizen of their property without the sanction of law. Reliance is placed on the judgment of this court in Tukaram Kana Joshi versus MIDC, wherein it was held that the state must comply with the procedure for acquisition, requisition, or any other permissible statutory mode. The state, being a welfare state governed by the rule of law, cannot arrogate to itself a status beyond what is provided by the Constitution. This court in State of Haryana versus Mukesh Kumar 2011 10 SCC 404 held that the right to property is now considered to be not only a constitutional or statutory right but also a human right. Human rights have been considered in the realm of individual rights such as right to shelter, livelihood, health, employment, etc. Human rights have gained a multifaceted dimension. We are surprised by the plea taken by the state before the High Court that since it has been in continuous possession of the land for over 42 years, it would tantamount to adverse possession. The state, being a welfare state, cannot be permitted to take the plea of adverse possession, which allows a trespasser, that is, a person guilty of a tort or even a crime, to gain legal title over such property for over 12 years. The state cannot be permitted to perfect its title over the land by invoking the doctrine of adverse possession to grab the property of its own citizens, as has been done in the present case. Stop.